Room 216 in the Hart Senate Office Building is one of the largest hearing rooms on Capitol Hill. You can see folks returning to the room back from the lunch break. They're set to resume in about 10 minutes or so. Those tables there you see on your screen are reserved for reporters. However, the hearing is open to the general public, and they distribute passes each morning at 8 o'clock. Passes are first come, first served, and visitors are allowed in for a limited time. These would be general public visitors. Obviously, we showed you some of the reserved seats for the family and members of the White House team and the Justice Department, too. The public's rotated through. So tickets open up, and they're free to the public at 8 o'clock each morning. The line for the next day starts when the current day's hearing has concluded. So tonight, 8 o'clock or so, they'll start lining up for Wednesday's hearing. Tomorrow's hearing gets underway at 9:30. We'll have another round of questioning, and I believe they're 20-minute rounds tomorrow with all 18 senators. And then there's Senator John Kyle of Arizona on your screen in the shirt sleeves. He'll be first up to finish up his 20 minutes of questioning. So 30-minute rounds today, 20 minutes tomorrow, and then later on Wednesday, they'll also have a closed session, not open to the public, an FBI background check session. Then on Thursday, they'll hear from witnesses.
One to the left. And then the other one. I know this one's under the seal. But
Reggie is no longer here. His work and Jerry is no longer here.
You know we have about it.
Work is strip off.
Okay. Hey, Ben.
You guys are hot already?
Jim Garrett.
Did they ever get it working?
That should be the first question asked. But nobody asked me today. Well, actually, you know what? I'll think about it.
Well, they said 30 minutes.
Oh, yeah.
Steve.
Are you okay with that?
very simple, and I like it. Okay. That's interesting. Maybe
Can I say, search the thing on the
Amy? Didn't Senator Brown back to except for... Did you go to that yet? In other words, the transcript doesn't actually go through. That's all right. Yeah, it is. We have it. Cool. Other than that...
Except no one expressed concern.
Hey, I almost forgot to tell you. Answer was on the fly.
This is day number 2 for the confirmation hearings of Samuel Alito. You'll see 20 minutes on the time clock there. This is a half an hour round of questioning. Senator John Kyle had 10 minutes before the breaks. There he is on the screen in the red tie. So he'll get his 20 minutes once they resume here in about 5 minutes or so. We have 7 Republicans left and 5 Democrats, all getting half an hour, except, as we mentioned, Senator Kyle with his 20 minutes.
Larry fell over once.
Buster's walking in over there.
And back from the lunch break, Samuel Alito returning to the committee room for another round of questioning.
Buster's in the room. Yeah, he is. He's too,
We all have our priorities.
No, I have allotted.
yeah, I can push into him if I go past a little bit.
Judiciary Committee hearings will resume. We'll turn now to Senator Kyle, who has 20 more minutes on his first round of 30 minutes. Senator Kyle.
Thank you, Mr. Chairman. First, let me ask unanimous consent to put 3 items in the record. One of these items related to, actually 2 of them relate to the matter of the CAP that we've heard something about. I'd like to enter into the record 2 letters by Democratic attorneys that make clear that Judge Alito has been extremely helpful in advancing the interest of women and minorities. One letter notes that as U.S. Attorney, he put women and minorities in supervisory positions. The other is from President-elect of the National Bar Association for Women, and also a Washington Post article from January 9th in which criminal defense lawyer and Democrat Alberto Rivas, who served in the U.S. Attorney's Office when Judge Alito was in charge, said, speaking of the judge, while he opposed numeric hiring quotas, he took steps to diversify an office that had the reputation as something of a white boys club. Mr. Chairman, I hope that this will help address what I think is almost getting to be
Without objection, they will be made a part of the record.
Thank you. Secondly, there's been some discussion of this Knight Ritter article that has, to my understanding, been rather completely discredited, and I ask unanimous consent that the attached document analyzing that article be added to the record.
Without objection, it will be made a part of the record.
And before the break, Senator Biden suggested that there, at least I understood him to suggest that there was no reason to belong to this organization, CAP, in 1985 because ROTC was safely on campus at that time. Judge, let me ask you a question. Do you know what year you joined the CAP?
I don't know, Senator. I've tried to rack my memory about that. But as I said, if I'd been active in my membership, I think I certainly would remember that. And if I had renewed the membership, I think I would remember that. So my best reconstruction of this is that it probably was sometime around the time when I wrote that statement in 1985.
Long after you were gone from the school.
That's correct.
In that event, Mr. Chairman, I ask unanimous consent to include in the record an article from a campus newspaper, the Princeton Packet, dated February 12, 1985, which expressly explains that ROTC was a core motivation behind the CAP in 1985.
Without objection, it will be made a part of the record.
Thank you, Mr. Chairman. I noted with interest a comment that Senator Durbin made in his opening statement because it referred to a good friend and former colleague of ours, Senator Simon, who put forth a pretty good test about courts. He said that the real test is the court restricting freedom or expanding it. And I thought about that because it seems to me that so many of these cases about expanding freedom or restricting it are cases that boil down to the eye of the beholder. And I specifically thought about the Ninth Circuit case because my state is from the Ninth Circuit, outlawing under God in the Pledge of Allegiance, saying that that's unconstitutional. And I checked. According to the one survey that I had access to, 93% of the American people support the right to say under God in the Pledge of Allegiance. And I know that the plaintiff in the case, Michael Newdow, thought that he was advancing his freedom or his daughter's freedom in successfully getting the court to strike it down. But it seems to me that the majority of the people are having their freedom restricted in such a case. And it seems to me, and I certainly won't ask you because that case could well come before the court again. I wouldn't ask you how you would rule on it. But as a general proposition, this matter of restricting freedom, is it not the case that in many situations you've got two competing types of freedom or liberty involved, and it's a question of interpreting the Constitution rather than specifically setting out to advance one sort of freedom as opposed to another?
I think that's exactly right, Senator. Often there are conflicting freedoms, and that makes the case difficult.
Let me ask you, too, there was a concern expressed by Senator Biden that the big factor in your nomination, in his view, was the fact that you would be replacing Justice Sandra O'Connor, and that might mean that you would change the direction of the court. That's the concern expressed anyway. Now, as has been famously said, I know Justice O'Connor. I've been a friend of hers for at least 30 years, and I don't think she is any kind of a liberal member of the court. She might properly be called moderately conservative. I'm not sure how she'd characterize herself. But I noted that of the 109 justices to sit on the Supreme Court, nearly half, 46 to be exact, have replaced judges appointed by another political party. So it is not at all uncommon. Indeed, it is almost half the situations in which a different party nominates the justice replacing a sitting judge. And or justice, and one might expect, therefore, some difference. But I checked the record, because this had been brought up by Senator Brownback yesterday, and I found in the nomination of Justice Ginsburg and the confirmation hearings there, she replaced Justice White, who I think rightly has been called a centrist on the court, certainly not a liberal, and yet I heard, or I saw, not one expression of concern by any senator, Democrat or Republican, that Justice Ginsburg might be ruling quite a bit differently than Justice White in decisions in the court. So it seems to me that that is not a test that is rightly applied. That's a results-oriented test, exactly the same kind of thing that you have said that judges shouldn't do when they approach cases. Let me get to a point that Senator Kennedy made. He said that you've been overly deferential to executive power and criticized what he called, and I think I have this quotation exactly, your almost total disregard of the impact of these powers on the rights of individuals. I'd like to know what your response is to that charge and whether you can cite some specific cases that would refute what he said.
Well, certainly, Senator. I've tried to decide every case on its own merits, and sometimes that means siding with the government, and sometimes it means siding with the party who's claiming a violation of rights. And I do it on an individual basis. Cases that show that I don't, that I do that are cases like United States versus Cathcart, which was a case in which an African-American man had been stopped by police officers because there had been a description of some robbery suspects, and they were described as the perpetrator was described as a black man in a black car, and Mr. Cathcart was a black man in a black car, and they thought that was sufficient to stop the car, and I wrote an opinion saying that that was insufficient, and that was basically racial profiling and was not permitted. Another example is Bolden versus Southeastern Pennsylvania Transportation Authority, which had to do with a drug test, and I found that the test there constituted a search and a seizure and would be a violation absent consent on the part of the party who was searched. There have been a number of criminal cases in which I've sided with the person claiming a violation of rights. Carpenter versus Vaughn was a case in which I wrote an opinion reversing a death penalty. I joined an opinion reversing a death penalty. The Bronstein case was another case that came up fairly recently in which I joined an opinion reversing a death penalty. There have been quite a few cases of this nature, Senator.
I noted a tax case, too, or a case involving tax evasion, Levito versus Lapina. Do you remember that 2001 case?
I do. That was the case in which there was a search of, I believe it was the office of a veterinarian, and in a way that is a similar case to the Malott case that I was discussing earlier, although in Malott I thought that the search was carried out properly. In the Levito case, on the facts of that case, I thought the search was not carried out properly, that the officers violated the Fourth Amendment in the way they went about carrying out that search. They forced the occupants of these premises to remain on the premises for a very extended period of time while the search was being conducted and violated their Fourth Amendment rights, and that's what I said in the opinion.
Do you have an idea of how many cases that have gone to decision that you've participated in on your 15 years as a circuit court judge?
I think it's well over 4,000 on the merits.
I suspect that in those 4,000 cases, there might be one or two that I disagree with your decisions on, maybe even more than that. But the point here is there are numerous cases in which you have found that the government acted improperly in criminal law contexts, in warrant contexts, in discrimination contexts, in other cases in which you have found either that the government acted properly or that at a minimum government officials were entitled to some immunity with respect to being privately sued. Is that correct?
That's correct, Senator.
Let me also address this question of discrimination, especially racial discrimination. This is a matter that was discussed in some prior questioning, and specifically in Senator Biden's questions, it dealt with the Sheridan case in which you were the sole dissenter. In the subsequent United States Supreme Court case, the Reeves decision, my understanding from your answer is that the Supreme Court addressed the same issue of law that you and your colleagues had disagreed about, and that the U.S. Supreme Court voted unanimously in an opinion written by Justice O'Connor that the test that you used in the Sheridan case was the correct test to use. Is that correct?
Yes, correct, Senator, that is correct.
Now, there are some other cases involving employees claiming racial discrimination that I've looked at, and one of the senators seemed to suggest in a comment that he made that you had never written opinions or decided cases for a black plaintiff. Is that a fair statement?
No, it's not accurate.
Do you recall cases that in which you upheld the discrimination claims of racial minorities?
There was the case of Gooseby versus Johnson & Johnson, and that case could be considered together with the Bray case that I was discussing before the break. Those were both cases in which my colleague Judge McKee wrote the opinion, and in the Gooseby case I agreed with him. It was a similar case, but it was a case where I thought the facts fell on the other side of the line. There was a case called Smith versus Davis, which was another case where I joined an opinion upholding the claim of an African American who was claiming racial discrimination. The Robinson case involved claims of race and gender discrimination. As I recall, there are a number of cases in the criminal law context. I just mentioned the Kithcart case. There was the Brinson case. There was Williams versus Price. There have been many cases involving other forms of discrimination, age discrimination, the Showalter case, disability discrimination, the Monzalewski case, the case of Shapiro versus Lakewood Township. There was Zuby versus AT&T, which was a case involving the statute of limitations for a claim of racial discrimination.
And you were the lone dissenter in that case, is that correct?
I was the dissenter in that case.
And your position was what?
My position was that, the majority's position was that the claim had to be thrown out because the statute of limitations had been violated. And my position was that the claim should be allowed to go forward because the statute of limitations was longer than the majority had recognized. And that case, that issue later went to the Supreme Court in a case called Jones versus Donnelly, and the Supreme Court agreed with my position that the longer statute of limitations applied.
I note there was another case involving an African American woman who claimed that her coworkers had made racial and sexual slurs against her, denied her training opportunities, and so on. And you ruled that she was entitled to $124,000 in damages and attorney's fees, a case called Reynolds versus USX Corporation. Do you remember that case?
Yes, that's right, Senator.
So the bottom line is there are numerous cases in which you have ruled in favor of minorities, in particular African Americans, in discrimination situations, and also where you've dissented in a situation in which your position was to support the claim of discrimination, and that it would be inaccurate to say that you have not taken that position in the 4,000 plus cases that you have decided. Is that correct?
That's certainly correct, Senator.
Now, there's been a lot of talk about precedent and stare decisis. It's certainly something that we lawyers are familiar with. We regard it as a key principle in deciding cases. There was a case that was mentioned by a couple of my Democratic colleagues that I'm sure will be discussed further, but I thought I'd give you an opportunity to talk about it because it certainly seemed to me to be a case in which you were that you were trying to apply a Supreme Court precedent, the precedent being the Lopez versus United States case, a case, by the way, in which I note that it's one of those decisions that Justice O'Connor was in the majority, a 5-4 decision, which her position could be characterized as the swing vote. Now, you in United States versus Rybar agreed with Justice O'Connor in the way that she should apply, or the way the law should be applied relative to intrastate possession of a weapon. The Lopez case dealt with a congressional act that said that weapons should not be possessed near schools. The court struck that down, saying that that went beyond the Commerce Clause capability of Commerce to legislate in matters of interstate commerce. In Rybar, what was the issue? You dissented. By the way, one of the reasons why this case is interesting to me is because the Ninth Circuit Court of Appeals, again, which is my circuit, has subsequently ruled, and this is not a conservative court in most people's estimation, recently agreed with your dissent in a case called U.S. versus Stewart, a 2003 case, in which the court overturned the defendant's conviction under the very same statute, holding that the law exceeded Congress's commerce powers. So it seems to me that it would be hard to argue that your position is per se unreasonable, but could you describe it in your own words?
Well, my position in Rybar was really a very modest position, and it did not go to the question of whether Congress can regulate the possession of machine guns. In fact, I explained in the opinion that it would be easy for Congress to do that in a couple of ways that differed from the way in which it was done in Rybar. The statute in Rybar was very similar to the statute that was at issue in Lopez. In fact, I think they are the only two federal firearms statutes that have been cast in that mold. They simply prohibited the possession of firearms without either congressional findings concerning the effect of the activity on interstate commerce or a jurisdictional element. And I knew from my experience as a federal prosecutor that most of the federal firearms statutes have a jurisdictional element right in the statute. And what that means is that when the prosecutor presents the case in court, the statute that's used most frequently is the statute that makes it a crime for someone who's been convicted of a felon to possess a firearm. And in that case, when the prosecutor presents the case in court, the prosecutor has to show that the defendant has been convicted of a felony and that the firearm in question had some connection with interstate commerce. Under Supreme Court precedent, a case called Scarborough, all that's necessary is to show that the firearm at some point in its history passed in interstate or foreign commerce. It was manufactured in one state and then later turned up in another state, or manufactured in a foreign country and brought to the United States. From my experience, this was never a practical problem, and this was how all the federal firearms statutes had been framed. But for whatever reason, the statute in Lopez and the statute in Rybar were lacking that jurisdictional element. So an easy way in which Congress could regulate the possession of a machine gun would be to insert a jurisdictional element. And as I pointed out as I just pointed out, in my experience as the U.S. Attorney in New Jersey, that was never a practical problem. The Supreme Court in Lopez said that there were three reasons why there was a problem with the statute there. And that case had been decided just the year before, and it was my obligation as a lower court judge to follow it. The first was that it involved what the court characterized as a non-commercial activity, and that was the possession of a firearm. And of course, that was exactly the same activity that was at issue in Rybar. The second was the absence of a jurisdictional element, and there was no jurisdictional element in either statute. And the third was the absence of a congressional finding connecting the activity that was being regulated with interstate commerce. And I pointed out in my opinion that I would have viewed the Rybar case very differently if there had been a congressional finding, or if the Justice Department, in presenting its argument to us, had been able to point to anything that showed that there was a substantial effect on interstate commerce, which is what the Supreme Court says is required.
So this is one of those situations in which if the result was not what was intended, you were willing to point out in your decision what Congress could relatively easily have done to get the result that it appeared that Congress wanted to achieve.
That's exactly correct.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Kyle. Senator Cole.
Thank you, Mitch. Thank you very much, Mr. Chairman. Judge Alito, we heard a lot of discussion yesterday about the proper role of the judge in our system. Some said that a judge should favor neither the, quote, big guy or the little guy, but simply apply the law and not make the law. Based on what you said yesterday, I believe that you would agree generally with this characterization. However, to me, it's not quite so simple. Just as no two umpires call the same game exactly, no two judges see a case in exactly the same way. Laws in the Constitution are often ambiguous and capable of many interpretations. Those interpretations are the result of judges with different judicial philosophies. Some judges have a more liberal judicial philosophy, while others are more conservative, and we're here trying to figure out what your judicial philosophy is. That's probably the principal point of this hearing. If the law were so simple, we would not have as many 5-4 decisions. It seems to me that many of the most fundamental protections of civil rights and civil liberties that we take for granted today, things such as school integration, principle of one person, one vote, the principle that the accused have a right to a lawyer in criminal cases, and the right of contraception, just to name a few, have come when judges have been willing to look beyond rigid legal doctrines that prevailed at the times of those rulings. The neutral approach, that of the judge just applying the law, is very often inadequate to ensure social progress, right historic wrongs, and protect civil liberties so essential to our democracy. So isn't it true, Judge Alito, that a neutral judge would never have reached these conclusions? In fact, for decades, courts did not reach these conclusions. So would you agree that these cases were rightly decided, number one, and required, number two, that judges apply a more expansive, imaginative view of the Constitution?
I think that the Constitution contains both some very specific provisions, and they are the job of understanding what the provision means and applying it to new factual situations that come up is relatively easy. The Constitution sets age limits, for example, for people who want to hold various federal offices, and there can't be much debate about what that means or how it applies. But it also contains some broad principles: no unreasonable searches and seizures, the guarantee that nobody will be deprived of life, liberty, or property without due process of law, equal protection of the laws. And in those instances, it is the job of the judiciary to try to understand the principle and apply it to the new situations that come before the judiciary. I think the judiciary has to do that in a neutral fashion. I think judges have to be wary about substituting their own preferences, their own policy judgments for those that are in the Constitution. They have to identify the principle that is to be applied under these broader provisions of the Constitution and apply it. But I don't see that as being the same thing as the judges injecting his or her policy views or preferences or ideas about the direction in which the society should be moving into the decision-making process.
But these decisions to which I just referred pushed society into new directions. And they came about, didn't they, as a result of Supreme Court's willingness, to look at the Constitution in perhaps a different way, in a new way, and take a new approach and a new avenue, which is not entirely consistent with a neutral judge simply applying the law. The law is the law. It's not hard to find that out, as you somewhat suggested. If you're an umpire, a ball's a ball, a strike is a strike. I'm suggesting that it's, and I think I would like to hope you would agree, it's somewhat, if not a lot more complex and sophisticated. If it weren't true, we could have a lot of views here today. I think you're unique in many ways, and part of that is your complexity, your sophistication, your ability to look at the Constitution and, if necessary, see new meanings that weren't seen there before. Isn't that true?
Well, Senator, I would never say that it's an easy process. There are some easy cases, but there are a lot of very difficult cases. And once you've identified the principle, the job of applying it to particular cases is often not easy at all. But what the judge has to do is make sure that the judge is being true to the principle that is expressed in the Constitution and not to the judge's principle, not to some idea that the judge has. And sometimes this results in groundbreaking decisions. Sometimes that's because new issues come up. Sometimes it's because the principle that is embodied in a constitutional provision has long been neglected. That was certainly true with respect to the Equal Protection Clause. There was a long period between Plessy versus Ferguson and Brown versus Board of Education when the true meaning of the Equal Protection Clause was not recognized in the decisions of the Supreme Court. And when Brown was finally decided, that was not an instance of the court changing the meaning of the Equal Protection Clause. It was an instance of the court writing an incorrect interpretation that had prevailed for a long period of time.
Okay. Judge Alito, one of the ways you get at a person's judicial philosophy is to look at the people whom they admire. In an interview that you gave in 1988, you were asked about your thoughts about Judge Robert Bork's nomination, and you said, and I quote, "Judge Bork was one of the most outstanding nominees of this century," unquote. Many Americans do not share Judge Bork's narrow views about the Constitution, views that would undermine many of the rights that we now take for granted, Judge Alito. Judge Bork thought that Americans had no constitutional right to use contraception, saying, and I quote, "The right to procreate is not guaranteed explicitly or implicitly by the Constitution," unquote. Judge Bork thought minorities had no constitutional right to have their votes counted equally, saying that in guaranteeing one man, one vote, the court, quote, "stepped beyond its boundaries as an original matter," unquote. In 1981, Judge Bork called Roe versus Wade, quote, "an unconstitutional decision, serious and wholly unjustifiable usurpation of state legislative authority," unquote. In addition, he had an unreasonably broad view of executive power, claiming that a law requiring the president to obtain an order from a court before conducting surveillance in the United States and against U.S. citizens for foreign intelligence purposes was, quote, "a thoroughly bad idea and almost certainly unconstitutional." Can we assume from your admiration of Judge Bork that you agree with some of these statements, or at least that you support some of these beliefs if you were sitting on the Supreme Court? Frankly, it's curious to me that someone like yourself would consider someone with his views to be, quote, one of the most outstanding nominees of this century.
Senator, when I made that statement in 1988, I was an appointee in the Reagan administration, and Judge Bork had been a nominee of the administration, and I had been a supporter of the nomination. And I don't think the statement goes beyond that. There are issues with respect to which I probably agree with Judge Bork, and there are a number of issues with which on which I disagree with him. And most of the things that you just mentioned are points on which I would disagree with him. I expressed my view about Griswold earlier this morning on the issue of reapportionment. As I sit here today in 2006, and I think that's what's most relevant, I think that the principle of one person, one vote is a fundamental part of our constitutional law, and I think it would be, I don't see any reason why it should be re-examined, and I don't know that anybody is asking for that to be done. Every legislative district in the country and every congressional district in the country has been reapportioned, has been redistricted numerous times in reliance on the principle of one person, one vote, and the old ways of organizing state legislatures have long been forgotten. So I think that's very well settled now in the constitutional law of our country. Under the Fourth Amendment, I have no question about the decision in United States versus United States District Court, which held, and I think that's what you were referring to, which held that a warrant is required for domestic security surveillance, and that was the decision that led to the enactment of the Foreign Intelligence Surveillance Act.
Of course, and I was only referring to, or trying to refer to, your quote with respect to him and the positions he held, which I suggested were at variance with the positions I thought you held, which you're affirming here in your answer. So that the quote you're pointing out was something you made as an employee of the Reagan administration?
I was, and that was in, I saw that quoted in the paper yesterday. I think
Right.
that was in 1980.
Not necessarily expressing your own real views?
I was a supporter of the nominee of the administration, and he was the nominee of the administration. He was and is an accomplished scholar. He had contributed a great deal to constitutional debate with his writings, and but I don't agree with him on a number of issues, and I've mentioned you've hit some of the issues on which I would definitely disagree with him.
Very good. Judge Alito, in the document appended to your job application, you also wrote that, quote, I disagree strenuously with the usurpation by the judiciary of decision-making authority that should be exercised by branches of government responsible to the electorate, unquote. The statement is especially troubling given that elsewhere in this application you wrote, quote, I developed a deep interest in constitutional law motivated in large part by disagreement with Warren Court decisions, particularly in the areas of criminal procedure, Establishment Clause, and reapportionment. Judge Alito, what Warren Court cases were you specifically talking about? Miranda, one person, one vote, any of the privacy decisions? What in particular were you talking about?
Well, Senator, I'm happy to address that. The statement was made in that 1985 form, and of course that was written 20 years ago, and in the form, what I was doing was sort of outlining the development of my thinking about constitutional law, and I went so far as to go back to my college days, which were before, of course, I had even attended law school, much less practiced law or served as a judge. I mentioned some of the leading areas that were covered by decisions of the Warren Court, and the decisions of the Warren Court really stimulated my interest in constitutional law. And I mentioned a book that had been published at the time, Alexander Bickle's book, The Supreme Court and the Idea of Progress, which was probably the first book about what you might call constitutional theory that I had read. And he was someone who I think most people would describe as a liberal, but he was a critic of the Warren Court for a number of reasons. And he was a great proponent of judicial self-restraint, and that was the main point that I took from my pre-law school study of the Warren Court. I spoke a bit about the reapportionment decisions. I don't believe that in fact, I'm quite sure I never was opposed to the one person, one vote concept. I do recall quite clearly that my father's work at the time, working for the New Jersey legislature and working on reapportionment, had brought to my attention the question of just how far that principle of one person, one vote had to be taken in drawing legislative districts. The New Jersey legislature and many other legislatures at the time were trying to redraw their districts in accordance with Reynolds versus Sims, which set out the one person, one vote principle, but it wasn't clear how exactly equal the districts had to be in population. And in some of the late Warren Court decisions, the court seemed to suggest, did say so for congressional districts, that they had to be almost exactly equal in population. And this idea, if applied to the legislatures and to the New Jersey legislative plan, would have wiped the plan out, because there were population deviations which, although not very large, were much larger than the court had said they were going to tolerate in the case of congressional districts. And I do remember that quite specifically. Professor Bickle made the argument that the court had taken the one person, one vote principle too far, and I know my father had said that although he thought it was a good idea, the idea of trying to get the districts to be exactly equal in population, at the expense of looking at other factors such as the shape of the district and respecting county lines or municipal lines, was a bad idea.
Judge Alito, you stated in that same job application that one element of the conservative philosophy that you believed very strongly, quote, very strongly, was the, quote, legitimacy of a government role in protecting traditional values, unquote. What traditional values were you referring to? And who decides what is a, quote, traditional value?
Well, again, I'm trying to remember what I thought about that 20 years ago, and I'm trying to reconstruct it. I think a traditional value that I probably had in mind was the ability to live in peace and safety in your neighborhood, and that was a big issue during the time of the Warren Court, and it was still a big issue in 1985 when I wrote that statement, because That was a time of very high crime rates. I think that's a traditional value. I think the ability of people to raise a family and raise their children in accordance with their own beliefs is a traditional value. I think the ability to raise a family, raise children in a way that they're not only subjected to, they're spared physical threats, but also psychological threats that can come from elements in the atmosphere is a traditional value. I think that the ability to practice your own conscience is a traditional value. That's the best I can reconstruct it now, thinking back to 1985.
Very good. Judge Alito, in Casey, you argued that the requirement that a woman notify her husband did not impose an undue burden upon a woman. You reasoned in part that the number of married women who would seek an abortion without notifying their husbands would be rather small. In other words, only some women who would be affected. The majority in that case disagreed with you and stated, quote, whether the adversely affected group is but a small fraction of the universe of pregnant women desiring an abortion seems to us irrelevant to the issue, unquote. This disagreement begs the question, is a constitutional right any less of a right if only one person suffers a violation, or should greater value be placed on that right if a larger number of people have that right violated?
Trying to apply the undue burden test at that time to the provisions of the Pennsylvania statute that were before the court in Casey was extremely difficult, and I can really remember wrestling with the problem, and I took it very seriously, and I mentioned that in my opinion, and it presented some really difficult issues. Part of the problem was that the law just was not very clear at that time. The undue burden standard had been articulated by Justice O'Connor in several of her own opinions, and there were just a few hints in those opinions about what she meant by it. But what she said was that an undue burden consisted of an absolute obstacle or an extreme burden. Those may not be exact quotes, but they're pretty close. And she did say that it was insufficient to show simply that a regulation of abortion would inhibit some women from going forward and having an abortion. That was the information that was available in her opinions to try to understand what this test meant. And so then the question became, how do you apply that to the numerous provisions of the Pennsylvania statute that were before us? And it was a difficult task. The plaintiffs argued that all of the provisions constituted an undue burden, and when the case went to the Supreme Court, Justice Stevens agreed with that. He said they all were an undue burden, things like a 24-hour waiting period. That was an undue burden because it would inhibit some women from having an abortion. An informed consent provision. Justice Stevens thought, and the plaintiffs argued, that would be an undue burden. The majority on my panel and the joint opinion on the Supreme Court found that most of the provisions of the statute did not amount to an undue burden. The 24-hour waiting period, the informed consent provision, and all of them. We disagreed on only one, and that was the provision regarding spousal notification with a safety valve provision there that no sort of notification was needed if the woman thought that providing the notification would present a threat of physical injury to her. And it was, I wrestled with that issue, but based on the information that I had from Justice O'Connor's opinions, it seemed to me that this was not what she had in mind. Now, that turned out not to be a correct prediction about how she herself would apply the undue burden standard to that statutory provision, but that was the best I could do under the circumstances.
Judge Alito, in your 1985 job application memo again, you identified reapportionment as one of the three issues decided by the Warren Court with which you disagreed. You even stated that your disagreement was so strong that it was one of the reasons that you became a lawyer. Supreme Court's Warren Court decisions on this topic, of course, stood for the fundamental principle of one person, one vote, meaning as a matter of constitutional law that each person's vote must count equally and each electoral district must have the same population. These decisions were more than 20 years old by the time of your 1985 job application. And these decisions stand for a fundamental principle of democracy. By 1985, virtually no serious scholar or constitutional lawyer could be found to disagree with the principle that each person's vote should count equally. So what was your disagreement with the Warren Court's decisions on this issue, Judge Alito, in 1985? Isn't one person, one vote basic principle of democracy? Wasn't it in 1985?
Senator, I don't believe that I disagreed with the principle of one person, one vote in 1985. I was talking about how I got interested in constitutional law back in college, and I was certainly stimulated at that time by my consideration of the issue of one person, one vote. But the issue that troubled me toward the end of the Warren Court, and this was during the time when I was in college, was the question of how far this principle went when it came to drawing legislative districts. Did they have to be almost exactly equal in population in accordance with the last census, or were larger population variations permitted? In a case called Kirkpatrick versus Priesler and another one called Wells versus Rockefeller that were decided around 1969, which was right at the end of Chief Justice Warren's tenure on the Supreme Court, the court held that in the case of congressional districts, they had to be almost exactly equal in population. And as I said, my father was deeply involved in this. When the issue came up again in the context of congressional districting in Karcher versus Daggett, which was around 1985, that was the case where he had been an expert witness, and the court struck down the New Jersey congressional districting plan, even though the population variations were under 1%. Now, the court also later said that when you're talking about legislative districts, considerably larger deviations are allowed, and you can take into account municipal lines and county lines and things of that nature. But as of the time when I was in college, as of the time of the two cases that I mentioned, it seemed likely, a lot of people thought, and certainly I as a college student thought that the rule was going to be the same for congressional districts as it was for legislative districts. And that seemed to say that the districts would have to be almost exactly equal in population based on the last census. Now, a problem with that is that while the census is very accurate, it's not perfect, and it doesn't stay accurate throughout the 10-year period from census to census. People move around, population grows, population diminishes in certain areas. So it didn't seem to make a whole lot of sense, let's say in the middle of a decade, to insist on absolute population equality based on the last previous census, when everybody knew that the census figures had changed. And in doing that, insisting on practically equal population districts, districts of almost exactly equal population, you disregard municipal lines, you disregard county lines, people don't know which district they're going to be voting in. You introduce the possibility of other factors figuring into the districting plan.
Right. Okay. Family and Medical Leave Act, Judge Alito. In my view, one of the most important pieces of social legislation enacted in the last two decades was the Family and Medical Leave Act in 1993. Among other things, it gives employees the right to take up to 12 weeks of unpaid leave to care for a newborn child or an ill parent or a spouse. The statute also gives an employee the right to sue his or her employer for damages if the employer violates the employee's rights under this law. I was disturbed to learn that in the Chittister case, Judge Alito, your ruling denied a state employee the ability to sue his employer for money damages. Your reasoning was directly repudiated by the 2003 Supreme Court decisions of Nevada Department of Human Resources versus Hibbs. In that case, the Supreme Court, in a decision written by Chief Justice Rehnquist, held that the Family Medical Leave Act was congruent and proportional to Congress's interest in preventing discrimination based on gender, and therefore states could be sued for money damages under the law. So we're concerned that your view shows a lack of understanding of the problems of ordinary working Americans, the right of women to be free of discrimination in the workplace. Isn't it true that under your view, potentially millions of working Americans would not get the protections that they rely on under the Family and Medical Leave Act? Judge Alito.
Well, Senator, I'm happy to address that because I think there's been some confusion about what the issue was in Chittister and how it relates to the Supreme Court's decision in Nevada versus Hibbs. I mean, there are actually two entirely different provisions of the Family and Medical Leave Act. The provision that was at issue in my case was not the one in Hibbs, and at last count, 7 circuits had decided that issue, the issue that was before my court in Chittister, exactly the same way we did. I counted up the number of Court of Appeals judges who endorsed that position, and it's over 20. I think it's 22. And they include some of the most distinguished Court of Appeals judges in the country and judges who have been appointed by presidents of both parties. The issue in Hibbs had to do with a provision of the Family and Medical Leave Act that requires employers to provide employees with a certain amount of leave for the purpose of taking care of another family member. The provision, and that was the one that the Supreme Court addressed in the Hibbs case. The provision in the Chittister case is a provision that requires employers to give employees a certain amount of leave for personal illness. The standard that has to be applied here is the one the Supreme Court has set out, and it's a controversial standard, but as a lower court judge, it's the one I had to apply, and that was whether what was done was congruent and proportional to constitutional violations. What the court said in Hibbs was that there was a record of constitutional violations, and remember, here we're talking about the provision that has to do with leave to take care of another person, and what they said was that there were many instances in which employers, state employers, had plans that provided more leave for that purpose for women than for men. And the reason was because of a stereotype that if somebody in the family got sick, it would be the woman, not a man, who would have to take off from work to take care of that person. But the provision that was at issue in Chittister had to do with leave for one's own personal illness. And there was no record that employers give, and a man was objecting to this, and there was no record that state employers, or for that matter any other employers, had plans that provided more sick leave for men than for women, or that any stereotypes were involved in the situation. And so that was why I concluded, and the unanimous panel that I sat on concluded, and all of these 7 other circuits concluded that that provision did not satisfy the standard that the Supreme Court had established.
Good. Last question. Judge Alito, I understand that you're reluctant to comment on cases that you would likely have coming before you in the future. But I'd like to ask you a question about a case that the Supreme Court certainly will never see again. 2000 presidential election contest between President Bush and Vice President Gore. Many commentators see the Bush v. Gore decision as an example of judicial activism, an example of the judiciary improperly injecting itself into a political dispute. Indeed, it appears to many of us who've looked at your record that Bush v. Gore seems contrary to so many of the principles that you stand for, that the President has said you stand for when making your nomination. Talking about judicial restraint, not legislating from the bench, and of course respecting the rights of the states. So, Judge Alito, I'd like to ask you, was the Supreme Court correct to take this case in the first place?
Well, Senator, I think you're probably right, and I hope you're right that that sort of issue doesn't come before the Supreme Court again. Some of the equal protection ground that the majority relied on in Bush versus Gore does involve principles that could come up in future elections and in future cases. But as to that particular case, my answer has to be, I really don't know. I have not studied it in the way I would study a case that comes before me as a judge, and I would have to go through the whole judicial process.
That was a huge, huge case, and I would like to hope, and I would bet that you thought about it an awful lot, because you are who you are. And I would like for you to give an opinion from the convictions of your heart, as a person who's very restrained with respect to judicial activism, this being a case of extreme judicial activism. Were they correct in taking this case, in your opinion?
Well, there's the issue of whether they should take it and the issue of how it should be decided. And Senator, my honest answer is I have not studied it in the way I would study the issue if it were to come before me as a judge. And that would require putting out of my mind any personal thoughts that I had on the matter and thinking about listening to all the arguments and reading the briefs and thinking about it in the way that I decide, in the way that I do when I decide legal issues that are before me as a judge. And that's the best answer I can give you to that question. It was obviously a very important and difficult and controversial case. And in a situation like that, the obligation of a judge all the more is to be restrained and not to go through the judicial decision-making process and only at the end of that reach a conclusion about the issue.
Thank you, Judge. Thank you, Mr. Chairman.
Thank you, Senator Kroll. Senator DeWine.
Thank you, Mr. Chairman. Judge, you've almost turned the corner here, so that's the good news. The bad news is this is just the first round. So, let me respond, if I could, Judge, to three things that I've heard so far during these hearings that have frankly disturbed me. First, I'm bothered by what I consider to be distortions of your record, really in an effort to make you look like something that you're not. I just read a very interesting article by Stuart Taylor from the National Journal about this issue, and I would like, Mr. Chairman, to make this a part of the record, this article, if I could. Mr. Taylor describes the opinions of a, quote, right-wing jurist. This judge has consistently ruled against minorities, striking down affirmative action programs, making it harder for victims of race and gender discrimination to vindicate their rights.
Senator DeWine, your unanimous consent request is granted.
Thank you, sir. This judge has struck down a federal law to protect kids from guns, ruled that state and local governments cannot be sued under the Fair Labor Standards Act, leaving 4.7 million workers without a remedy in court. This judge has immunized the president from suit, even when he illegally wiretaps political opponents. This judge approved a police officer's fatal shooting in the back of an unarmed 15-year-old African-American boy. Finally, this judge has called abortion, and I quote, morally repugnant, and declared Roe v. Wade to be on, quote, on a collision course with itself. Based on such a record, no right-thinking Democrat could ever support such a judge. But as Taylor tells us, this judge is none other than Sandra Day O'Connor. The same Sandra Day O'Connor who has been praised over the past few days as a model of moderation. Judge, the point Mr. Taylor made is clear. You can distort and misrepresent anyone's record. And that, I believe, unfortunately, is what some of your opponents are doing to you. It's unfair, it's inaccurate, and it's just flat out wrong. Second, I would like to respond to the allegation that you have not written an opinion in favor of plaintiff alleging race discrimination on the job. You did a very good job a moment ago when Senator Kyle was talking to you and describing some of these cases. I think the facts of these cases are what is particularly interesting. In Reynolds versus USX Corporation, you ruled that an African-American woman whose co-workers and supervisors regularly made racial and sexual slurs against her and denied her training opportunities was in fact entitled to $124,000 in damages and in attorney fees. Zuby versus AT&T Corporation, you dissented, arguing against a stringent limitations period which prevented a civil rights plaintiff from filing a claim, and your position was vindicated. You were vindicated by the United States Supreme Court unanimously a few years later. In Smith v. Davis, you disagreed with the district court, which had dismissed an African-American employee's claim of discrimination. Instead, you found that there was evidence to support a finding that the employer's stated reasons for firing the plaintiff were not genuine. In Gooseby versus Johnson & Johnson, you ruled that the plaintiff, an African-American woman, was entitled to a trial on her claims of employment discrimination because you found that there was evidence that the employer was treating white male employees differently than it was treating the plaintiff. There are more cases, as you've testified to, but I think we make the point. We would all be better off, and this process, Mr. Chairman, would be better off and it would be more instructive if we could evaluate your nomination, Judge, based on your full and complete record. And finally, let me add my 2 cents on this Vanguard issue. I'm going to take it from a little different perspective than has been done so far. To me, this is really a non-issue. In the so-called Vanguard lawsuit, 2 people were in a financial dispute. The plaintiff sued to force the defendant to turn over $170,000 held by him in some Vanguard accounts. The defendant went to court to prevent Vanguard from turning over the money. Now, while Vanguard was technically part of the suit and was technically a defendant, it wasn't really a defendant in any sense of the term that would be used by the public or understood by the public. It was not accused of any wrongdoing. It didn't stand to lose anything. The only question was whether Vanguard would transfer some of the funds it held for one person over to another. It was simply being asked, who do I pay the money to? Who do I give the money to? That's all Vanguard was being asked to do. So nothing in the classic sense of being a defendant. Nothing about this case could realistically have affected Vanguard as a company, let alone affected your mutual funds. It's a joke. It's ridiculous. It's absurd. And everybody on this panel knows that. Now, for the sake of the process, I hope we can put these issues behind us. This hearing is really our opportunity to fully and fairly evaluate your qualifications for the High Court and to get some idea about how you think as a judge, how you process things, what kind of a judge you will be on the United States Supreme Court. Now let me turn to the substance. Judge Alito, I want to turn to an issue that is very important to me. In a number of recent cases, the Supreme Court of this country has restricted congressional power in a way that I think is not required by the Constitution. In my opening statement, I mentioned the Supreme Court's decision in Board of Trustees versus Garrett, a 5-4 decision. To me, that case is the best example of this recent trend, and it's not a good trend, in my opinion. Garrett involved a woman who claimed that she had been discriminated against because she was disabled. She was employed by the state of Alabama, and she sued the state under the Americans with Disabilities Act. The Supreme Court threw out the suit, however, holding that Congress lacked the power to make the state subject to suit. Now, Judge, as I see it, the problem with Garrett is that the court ignored findings made by Congress. While we were considering the ADA, we held 13 hearings and even set up a task force that held hearings in every state in the Union, attended by more than 30,000 individuals. Based on these hearings, we found hundreds of examples of people with disabilities being discriminated against by the states and in employment decisions. Further, we found that, and I quote, 2/3 of all disabled Americans between the ages of 16 and 64 were not working at all, even though a large majority of them were capable of doing so. And finally, we found that this discrimination flowed from, and I quote, stereotypic assumptions about people with disabilities as well as, and I quote, purposeful unequal treatment, end of quote. Sadly, however, in Garrett, the court said that this was just not enough. In fact, it held that we had not pointed to any evidence that the states discriminated in employment decisions against people with disabilities. Judge Alito, from a review of your decisions, it appears to me that you tend to defer in close cases to the decisions of those individuals closest to the problem at hand. I applaud you for taking that approach. Now let me ask you, in your opinion, What role should a judge play when reviewing congressional fact-finding? And how can you assure us that you will show appropriate deference to the role of Congress as the representative of the people in this democracy when we pass important legislation?
I think that the judiciary should have great respect for findings of fact that are made by Congress. And in the Rybar decision that I was discussing earlier, although it is controversial and it involved an application of the Lopez decision, I stated that that decision would have been very different, that case would have been very different for me if Congress had made findings. And that's because of two things. I am fully aware of the fact that the members of the judiciary are not the only officers in the United States who take an oath to support and defend the Constitution of the United States. The members of Congress take an oath to support the Constitution, and officers of the executive branch take an oath to support the Constitution, and I presume that they go about their work in good faith. The second point, and this goes directly to the issue of findings, is that the judiciary is not equipped at all to make findings about what's going on in the real world, not this sort of legislative findings. And Congress, of course, is in the best position to do that. You have constituents, members of Congress hear from their constituents. Congress can have hearings and examine complex social issues, hear testimony, receive statistical data, hear testimony from experts, analyze that and synthesize that and reduce that to findings. And when Congress makes findings on questions that have a bearing on the constitutionality of legislation, I think they are entitled to great respect.
Well, Judge, I appreciate your response. We can't ask you, obviously, decide any particular case, but what we're trying to do today is get a general idea of how you approach cases, and we've looked at, as I said, looked at your previous cases. We have a pretty good idea from that, but I appreciate this exchange. Let me follow up with this. Garrett is the law of the land today. Nonetheless, let me ask you whether after Garrett, Congress might still have a way to protect the disabled. Rather than focus on the problem caused by Garrett, let me focus on the solution. To me, even after Garrett, Congress still has the power to protect the disabled under the spending clause of the Constitution. I'd like to explore maybe that with you if I could. Let me give you an example of how this might work. You're, of course, very familiar with South Dakota versus Dole. In that case, Congress had wanted to establish a national drinking age of 21. As you know, we, of course, don't have the power to require that under our Constitution. Therefore, Congress used its power under the spending clause. We said to the states, if you don't establish a 21-year-old drinking age, you will lose 5% of your federal highway dollars. This left the states with a choice: adopt a 21-year-old drinking age or lose 5% of their federal money. When presented with such a choice, the states kept the money and changed their drinking age to 21. It seems to me that Congress might be able to use this same approach to require the states to waive their immunity from suit under statutes like the ADA. Judge, based on your experience, could you give me your understanding of what Congress can do and what it can't do under its spending clause power? Maybe just go back and look at some recent cases and give me a little.
Yes, certainly, Senator. Well, I think you've pointed to the leading case in this area, and that's South Dakota versus Dole. And South Dakota versus Dole recognizes that Congress has broad powers under the spending clause, and that when Congress provides money to the states, Congress can attach conditions to that money, to the receipt of the money, provided that certain standards are met. One thing that has to be done under the Supreme Court's cases is that there has to be a clear statement that the conditions are attached to the receipt of the money. The Supreme Court views this like a contract, so that the parties need to have, the party receiving the notice has to have clear and fair notice about what it's agreeing to by taking the money. And then beyond that, the condition, if that's satisfied, then the condition has to be germane to the purposes of the funds. And in South Dakota versus Dole, the court found that the drinking age and the 55-mile-an-hour speed limit were germane to the purpose of the expenditures, and these, I believe, were federal highway funds. So those are the standards that would be applied to any future legislation under the current precedents if the future legislation invokes Congress's broad power under the spending clause.
That's helpful. Thank you, Judge. During the confirmation hearing of Chief Justice Roberts, Chairman Specter showed us a chart stating that the Supreme Court had the opportunity to overrule Roe v. Wade in 38 cases. Because of this, the chairman suggested that Roe was not only super precedent, but super duper precedent. Chairman has made the same argument at the hearing today. In fact, he brought the chart out again today. Now, Judge, just to show you that not all members of this panel are like-minded, I want to tell you that I disagree. To me, Roe is not super precedent. I believe Roe is precedent, but I don't believe it's super duper precedent nor super precedent. First, although the court has applied Roe in 38 cases, it has not directly taken up the issue of whether to overrule Roe in every one of those cases. In fact, out of those 38 cases, I've only found 4 in which the court directly addressed the status of Roe as binding precedent. In Webster, the court asked whether Roe should be reaffirmed, but ultimately avoided the issue. In 3 cases, City of Akron, Thornburg, and Casey, the court did reaffirm Roe. But the last of these cases did so in a way that hardly left Roe on firm footing. In fact, Casey altered Roe by eliminating the strict scrutiny standard of review and replacing it with a lesser undue burden test. The result has been that many restrictions on abortion have been upheld. Second, just because Roe has been applied and reaffirmed does not make it a special form of precedent. Many other cases have been applied for decades before eventually being overruled. For example, Plessy versus Ferguson. The case establishing the principle of separate but equal was upheld for nearly 60 years before it was overruled, and certainly discredited today. Lochner versus New York, a case that greatly limited the power of the states to protect children and workers, was consistently applied for more than 30 years before it was overruled. And Swift versus Tyson, a case establishing the doctrine of federal common law, was a bedrock principle of American law, repeatedly applied and upheld for nearly 100 years before it, too, was struck down. Thus, the mere fact that Roe has been upheld for more than 30 years does not mean that it is entitled to special deference. Third, from the start, Roe has been criticized by lawyers, scholars, and judges, whether Democrats or Republicans, and to date it does remain controversial. Fourth, much has happened over the last 30 years to undermine the soundness of Roe. Senator Brownback has mentioned how the facts of Roe have changed. We now know that the plaintiff in Roe based her case on false statements and that she wants the case overturned. We also know much about the life of babies in utero that we did not know 30 years ago. We even know something about the internal deliberations of the justices who decided Roe. In an internal Supreme Court memo, Justice Harry Blackmun, the author of Roe, acknowledged that the trimester framework established in his opinion was, and I quote, arbitrary. And Justice Lewis Powell said that he could not find a right to an abortion within the Constitution and decided instead to rely on his gut. Finally, whatever the term precedent, super precedent means, I do not think that it describes Roe. In an article by William Landis and Richard Posner, super precedent was defined this way. It is a, and I quote, precedent that is so effective in defining the requirements of the law that it prevents legal decisions arising in the first place, or, if they do arise, induces them to be settled without litigation, end of quote. In other words, super precedent is precedent that is so firmly entrenched in our legal system that people simply don't question it. Marbury versus Madison, the case establishing the power of judicial review, is super precedent. It's so well settled that litigants do not challenge it in court. In fact, it is one of the fundamental assumptions upon which our constitutional system is built. Roe is hardly Marbury. Is Roe Supreme Court precedent? Certainly. But in my view, it is not super precedent or even, it's not super duper precedent or even super precedent. It is precedent, nothing more. Judge, I want to turn now to another topic, to an issue that several federal judges in Ohio have brought up to me during our conversations. As you know, the Supreme Court currently decides about 75 cases a term. This number is down dramatically from where it was just a generation ago. 1976, for example, the court decided almost 400 cases on the merits, more than 5 times what it does today. This incredible shrinking Supreme Court docket has been the focus of much attention over the past few years, a lot of discussion. And one result of the court deciding fewer and fewer cases is that more and more circuit splits are left unresolved, which is what I want to talk to you about. As we all know, a circuit split occurs when 2 or more federal courts of appeals disagree on an issue of federal law. As of late, circuit splits have become so pervasive that the Seton Hall Law School came out last year with a new law review dedicated exclusively to that issue. There is also a website written by a law professor at the University of Richmond solely committed to identifying new circuit splits. Hardly a week passes when at least one does not emerge. To me, these pervasive and unaddressed circuit splits create 3 problems. 1, organizations that transact business across state lines get caught in the crosshairs of this confusion, being subject to one interpretation of federal law in California and a different one in the state of Ohio. 2nd, federal judges are placed in a difficult situation of trying to figure out what the law requires. In fact, a number of federal judges in Ohio have talked to me, as I said, about this. And finally, circuit splits undermine the goal of having uniformity in our federal law. Let me just ask you, what is your opinion about this issue? In your experience, has the Supreme Court's shrinking docket caused problems for businesses, lower court judges, and individuals? Is there a problem with the number of unresolved circuit splits? And if the court takes more cases, do you think that will solve the problem?
Well, that's a difficult issue for me to address from my current position as a judge of the Court of Appeals, because the Supreme Court is my boss, and I am reluctant to suggest that I think they should be doubling their workload. That's not the sort of thing.
Go ahead.
That's not the sort of, or even increasing it at all, that's not the sort of thing that subordinates generally do regarding superiors. The issue, but circuit splits are certainly undesirable, and I think everybody recognizes that, and that's one of the grounds for granting certiorari. I know that when Justice White was on the court, he regularly would dissent from the denial of certiorari in cases where there was a circuit split, because he felt strongly that circuit splits should be resolved by the Supreme Court. I have friends, former colleagues from prior times in my career who are appellate attorneys who specialize in cases before the Supreme Court and in appellate litigation generally, and occasionally I hear them complain about unresolved circuit splits that are difficult for their clients, and so I'm aware of their complaints. I haven't personally kept track of the number of circuit splits that exist, but certainly they are an undesirable thing, and it is a ground for granting certiorari. And I think one of the jobs that the Supreme Court has is to iron out circuit splits. There can be disagreements about whether there really is a circuit split, obviously, in a particular case, and there can be differences of opinion about the timing for resolving circuit splits. Sometimes the Supreme Court thinks it's advisable to wait and see how an issue plays out in a number of circuits before the Supreme Court decides to take on the issue, and that may improve their ability to resolve the issue when the case when the case eventually comes before them.
Well, Judge, let me just suggest that I think it's a problem, and I think the Supreme Court needs to deal with it. Chief Justice Roberts indicated that he thought the court could take on more, and I would suggest that it could. So I appreciate your comments. Judge Alito, let me ask you about Congress's power to protect our children from the proliferation of pornography on the Internet. This is an important issue. I raised it at the last hearing. It's one that I think is very troubling. Congress has tried several times to protect our children from being exposed to pornography on the Internet. In 1996, we passed the Communications Decency Act, but the Supreme Court struck it down, citing the First Amendment. A few years later, we passed the Child Online Protection Act. Again, the court struck it down. What bothers me about these cases is they fail to account for something that to me seems relatively simple. At the core of the First Amendment is the protection of political speech. But it seems to me that pornography is altogether different. Unlike political speech, pornography has very little value, if it has any value at all. It doesn't communicate a message other than one that degrades women. It does not contribute to the public debate, and actually causes harm to the victims who take part in making it and those who use it. There are, of course, a number of cases that seem to recognize that pornography is of lesser value speech. In Young versus American Mini Theaters, the court upheld zoning regulations on adult theaters. In doing so, Justice Stevens had this to say, and I quote, "Even though we recognize that the First Amendment will not tolerate the total suppression of erotic materials that have some arguably artistic value, it is manifest that society's interest in protecting this type of expression is of a wholly different and lesser magnitude than the interest in untrammeled political debate." Let me ask you, Judge, what is your thinking on this subject? Is pornography lesser value speech, as Justice Stevens has seemed to suggest, and are there or should there be different levels of speech under the First Amendment?
I think that the problem of protecting children from pornography on the Internet illustrates the fact that although the task of the judiciary is to apply principles that are in the Constitution and not make up its own principles, to apply those to different factual situations, when the world changes, and in particular when, in the First Amendment context, when means of communication changes, the job of applying the principles that have been worked out, and I think in this area worked out with a great deal of effort over a period of time in the pre-internet world, applying those to the world of the Internet is a really difficult problem, and I understand that Congress has been struggling with it, and I know the judiciary has been struggling with it. The law, of course, as you know, constitutional law draws a distinction between obscenity, which has no First Amendment protection but is subject to a very strict definition, and pornography, which is not obscenity but is sexually related materials. With respect to minors, the Supreme Court has said that it's permissible for a state to regulate the sale of pornography to minors. It has greater authority there. I think that's the Ginsburg case. It has greater authority there than it does with respect to the distribution of pornography to adults. Now, in the pre-internet world, the job of preventing minors from purchasing pornography was a lot simpler. If they wanted to get it, I guess they would have to go to a store or someplace and buy it. But on the Internet, of course, it's readily available from any computer terminal, and a lot of minors today are a lot more sophisticated in the use of computers than their parents. So the ability of parents to monitor what they're doing and supervise what they're doing is greatly impaired by this difference in computer aptitude. And I can't say much more about the question than that. It is a difficult question. I think that there needs to be additional effort in this area, probably by all branches of government, so that the law fully takes into account the differences regarding communication over the Internet and access to materials over the Internet by minors.
Judge, I have one last question. If confirmed by the Supreme Court, only part of your job will be hearing arguments and issuing opinions. An equally important part of the job will be involved deciding which cases to hear in the first place. Each year, the Supreme Court receives approximately 8,000 petitions for cert. Cert petitions, as they are called. These are petitions by a party to a lawsuit asking the court to hear its case. Out of these 8,000 annual requests, the court decides to hear only about 75 to 80. For many years, individual justices would review each cert petition and cast a vote on whether to hear the case. Today, however, 8 of the justices are part of what is called the cert pool. Here's how it works. All petitions are put into a pool. A single law clerk then picks up a petition and writes a memo recommending for or against hearing the case. That memo is then circulated to the 8 justices in the cert pool, who use it to cast their vote on whether to hear the case. Justice Stevens is the only one who does not participate in this pool. Instead, he has his staff prepare a memo on each case with a recommendation tailored to his own thinking on an issue. It would seem to me that the cert pool greatly limits the exchange of ideas among members of the court. I wonder if you could tell me how you would intend to proceed, if you're going to use the pool or if you're going to do what Justice Stevens does, or if you've thought about it.
I'm aware of the issue, but I have not thought past what might happen with these confirmation proceedings. So it's not the kind of issue that I have really thought through in my mind. If I'm fortunate enough to be confirmed, I think I would assess the situation at that time and talk to the Supreme Court justices and see what their views are, the reasons why they're proceeding in one way or another. I know from my perspective as a lower court judge that there is a constant conflict between the obligation that we have to deal with a very heavy caseload and the need for the judge, as opposed to a law clerk or a staff employee of the court, to deal with the cases. We cannot delegate our judicial responsibility, but we do need to call on, we need to find ways, and we do find ways of using, of obtaining assistance from clerks and staff employees so that we can deal with the large caseload that we have.
Thank you, Judge.
Thank you, Senator DeWine. Senator Feinstein.
Thank you very much, Mr. Chairman. Good afternoon, Judge. Because Sandra Day O'Connor was the 5th vote on both Lopez and Morrison, I think I'd like to start with the Commerce Clause and your views of federalism. Do you agree with the direction the Supreme Court took in Lopez?
Well, Senator, that really relates to the next case in the Lopez Morrison line of cases that might come before the Supreme Court, and so I don't know how I can address that question without knowing what that case is, and of course, my resolution of it.
I was just asking you about Lopez, but
well,
Lopez
is a precedent of the court, and it's been followed in Morrison, and then it has to be considered in connection with the Supreme Court's decision in Raich, and I think that all 3 of those have to be taken into account together. I don't think there's any question at this point in our history that Congress's power under the Commerce Clause is quite broad, and I think that reflects a number of things, including the way in which our economy and our society has developed, and all of the foreign and interstate activity that takes place. We do still have a federal system of government, and I think most people believe that that is the system in which that's set up by our Constitution.
Right. Now, having said that, I pulled the Rybar case and read it over the noon break, and let me just see if we agree on the facts, and stop me if you think I'm misquoting or misstating anything. The Rybar case essentially took place the year after Lopez. It involved Mr. Rybar, who was a federally licensed gun dealer, who went to a gun show in Pennsylvania and bought a Chinese-type 54 7.62 millimeter submachine gun one day, sold it to Mr. Bobbitz, went back the next day, and sold him a military M3 45 caliber submachine gun. The grand jury indicted him on 2 counts of unlawful possession of a machine gun in violation of the law and 2 counts of unlawful transfer of an unregistered firearm. He changed his plea, pled guilty to 2 counts, I think pled conditionally guilty to 2 counts. And when the case came before you, and I read with great interest your dissenting opinion, and what you said was, and I quote, "If Lopez, which happened the year before, does not govern this case, then it may well be a precedent that's strictly limited to its own peculiar circumstances. But our responsibility is to apply Supreme Court precedent. That responsibility, it seems to me, requires us to invalidate the statutory provision at issue here in its present form." And then you went on to say that the present form, quote, "might be sustainable in its current form if Congress made findings that the purely intrastate possession of machine guns has a substantial effect on interstate commerce, or if Congress or the executive assembled empirical evidence documenting such a link. If, as the government and the majority boldly insist, the purely intrastate possession of machine guns has such an effect, these steps are not too much to demand to protect our system of constitutional federalism." So if I understand this, you essentially said that you wanted to follow precedent, newly established law in this area, and you left a little hedge that if the Congress did make findings in that law, then that might be a different situation. If Congress did make findings, would you have agreed that that statute would have been constitutional?
Well, what I said in the opinion and what I will reiterate this afternoon is that it would have been a very different case for me. I don't think I can express an opinion on how I would have decided a hypothetical case.
It's not hypothetical. I'm just asking you, if there were findings, as you said, you might have sustained the law.
And I reiterate that.
And I'm just asking
I
you,
think it
would
would
you
have
have
been,
sustained the law if there were findings?
I don't think that I can give you a definitive answer to the question because that involves a case that's different from the case that came before me. But I repeat what I said there. It would have been a very different matter if Congress had made findings. I have the greatest respect for findings. This is an area where Congress has the expertise and where Congress has the opportunity to assemble facts and to assess the facts. We on the appellate judiciary don't have that opportunity. So if Congress had made findings, and I didn't insist on findings, if the executive branch, which was defending the statute, had pointed to testimony at hearings, and that's been done in other Commerce Clause cases, or statements by responsible government officials with expertise in the area of firearms control, or any other evidence that substantiated this, it would have been a very different case for me. And of course, if there had been a jurisdictional element, then I think it's perfectly clear under the precedents that it would have been constitutional.
Okay. Well, I accept that with one exception. I think most people know that particularly machine guns do affect interstate commerce. And there's generally no question about that. If one looks at a gun trace, even before Mr. Rybar had the gun, the likelihood was that it came across state lines, particularly the Chinese model. So yeah, I think that's a difficult extrapolation for me to understand, but that's not necessarily dispositive. Let me go on. At the conclusion of your dissent, you wrote that, quote, "Even today, the normative case for federalism remains strong," end quote. Now, federalism is often used to describe the strengthening of state powers at the expense of the federal government. What exactly did you mean by that statement?
I meant that there are activities that, and I think there's general agreement on this, and it goes beyond what the Constitution requires into areas of policy that I think Congress respects, that I think there's general agreement that there are some activities that have traditionally been handled by the states and by local governments, and those are areas in which they have taken the lead because the view has been that they're in a best position to deal with that. And that was the issue that was directly addressed by Justice Kennedy's concurrence in Lopez. He relied in large part on the fact that he put heavy reliance on the fact that what was involved in Lopez was a law relating to schools. And although the federal government certainly has a role in education, traditionally that has been regarded as something that is primarily to be handled at the state and local level.
Okay. Now, you cited a law review article by a professor named Stephen Calabresi. In that article, he argues that Lopez was a revolution that shattered forever the notion that after 50 years of Commerce Clause precedent, we could never go back to the days of limited national power. Do you agree with that?
I agree that Lopez was a startling development for a lot of people. When I was in law school, I think the traditional wisdom was that the commerce power reached everything, that there was no limit to the power, that nothing could ever exceed the power. And Lopez and the Lopez line of cases have not made huge inroads on that principle, but it was the first time in a long time that a statute had been held to exceed Congress's commerce power. So to that extent, yes, it was a revolution, but how big of a one?
I would say not yet has it made that kind of a dent. And that's why your nomination is so important, because you could be a decisive vote in this area. Do you believe that the Supreme Court's Commerce Clause decisions in the 50 years preceding Lopez are settled law?
I think that I'd have to talk about individual cases, but I do think that most of those are, the ones that come to my mind, I think are well-settled precedents.
Okay. Now, unlike the machine gun law in Rybar, the Family and Medical Leave Act in Chittister did include congressional findings of fact, as the Supreme Court confirmed, and yet you authored the majority opinion to invalidate the law.
Well, in Chittister...
Do you see a contradiction in that?
I don't, Senator. I don't believe that there were congressional findings in Chittister that went to the issue in Chittister.
Okay, that's good. Now let me ask you some questions. Is it enough for Congress to provide findings of fact in a statute, or do the findings of fact need to be deemed sufficient by a court?
Well, what the Supreme Court has said is that findings of fact are very helpful when they are provided, and the court will certainly treat them with respect. But they are neither, they're not necessarily definitive, and they also are not necessary. Congress doesn't have to make findings. It's helpful when it does it, and under the Supreme Court's cases, the findings are not necessarily definitive. That's what the Supreme Court has said about this.
But you struck down Rybar. Ostensibly, you said it would have a much better chance with you if it had findings of fact. And this was a case where prior laws had major findings of fact with respect to machine guns. I mean, this wasn't a new thing.
Senator, I looked very carefully at all of the materials that were cited by the other judges in Rybar and that were provided by the government. And the things that were cited from the legislative history of the prior statutes did not, in my view, go to the issue in Rybar. All of those prior statutes were statutes that had jurisdictional elements in them. All that I was looking for was some evidence that the possession of a machine gun, not the transfer of a machine gun or the sale of a machine gun, but the mere possession had a substantial effect on interstate commerce. That's what I understood the Supreme Court precedent to require. And it's not a very heavy burden to show that something has a substantial effect on interstate commerce, but that's what I understood the Supreme Court precedent to require, and that's what I was looking for.
Okay, let's move to the issue of a woman's right to choose and Roe. This morning, Senator Specter talked about how Casey reaffirmed the original soundness of Roe and then put emphasis on precedent. And he then asked, how would you weigh that consideration were this issue to come before you if concerned? And in response, you said, and I'd like to quote, well, I agree that in every case in which there is prior precedent, the first issue is the issue of stare decisis. And the presumption is that the court will follow its prior precedents. There needs to be a special justification for overruling a prior precedent. Can you give us a few examples of a special justification, not including Brown v. Board of Education, which you think would qualify?
There are a number of factors that figure in the application of stare decisis in particular cases. There are factors that weigh in favor of stare decisis, and there are factors that weigh against stare decisis. Factors that weigh in favor of stare decisis are things like what the initial vote was on the case, the length of time that the case has been on the books, whether it has been reaffirmed, whether it has been reaffirmed on stare decisis grounds, whether there has been reliance, the nature and the extent of the reliance, whether the precedent has proven to be workable. Those are all factors that have to be considered on an individual basis.
I'm asking you for what it would be the special justification that you mentioned this morning that would be needed to overcome precedence and reliance.
Well, I think that what needs to be done is a consideration of all of the factors that are relevant. This is not a mathematical formula. It would be a lot easier for everybody if it were, but it's not. The Supreme Court has said that this is a question that calls for the exercise of judgment. And they've said there has to be a special justification for overruling a precedent. There is a presumption that precedents will be followed, but it is not, the rule of stare decisis is not an inexorable command. And I don't think anybody would want a rule in the area of constitutional law that pointed in that said that a constitutional decision, once handed down, can never be overruled. So it's a matter of weighing taking into account all of the factors and seeing whether there is a strong case based on all of the relevant.
My question was a different one, respectfully.
I'm sorry, Senator.
It was, can you give me a few examples of what you think would qualify as a special justification for overruling prior precedent? And the reason I ask you this is in our private conversation, you said to me that you didn't think there had been any case you could think of that had been more tested than Roe.
Well,
So
Roe has...
What special circumstance would there be which would overcome this kind, whether you call it super precedent or super duper or anything, but this kind of protracted testing over a 33-year period of time?
All right, Senator, I'm sorry if I didn't understand your question previously. One situation in which there is a special justification for overruling a precedent is if the rule has proven to be unworkable. An example where the Supreme Court thought that a rule had proven to be unworkable is provided by National League of Cities and San Antonio Transit Authority versus Garcia. National League of Cities asked whether something was traditionally a sovereign function. And that resulted in a whole series of cases in the lower courts, a large number of cases in the lower courts, and a number of cases in the Supreme Court, in which the courts had to decide whether something was on one side of this line or not, and it proved, in the view of the Supreme Court, to be a very difficult standard to work with. And finally, in Garcia, they said this is unworkable, and we are going to overrule National League of Cities, and we are going to leave it to Congress to deal with the federalism issue that's presented here. This is an example of Congress, of the Supreme Court saying there's a federalism concern here, but it's one that Congress rather than the court would have to deal with. Sometimes changes in the situation in the real world can call for the overruling of a precedent. An example of that is provided by Katz versus United States, which I was talking about this morning in relation to wiretapping. The old rule under Olmstead was that in order for there to be a search, you had to look to property law. You had to see whether there was an invasion of a property interest. And then with the development of electronic communications and electronic surveillance, wiretapping, or other forms of electronic surveillance, which is what was involved in Katz, the Supreme Court said that this isn't a sensible way to apply the Fourth Amendment principle under the conditions of the modern world. And they said famously that the Fourth Amendment protects people, not places. So they shifted. They found the doctrinal underpinnings of the old Olmstead rule to be undermined by developments in the society, and they shifted the focus from property law to whether somebody had an expectation of privacy. So those are examples.
Well, and you did say that you believe the Constitution provides a right of privacy.
I did say that. The 14th Amendment protects liberty. The Fifth Amendment protects liberty. And I think it's well accepted that this has a substantive component, and that component includes aspects of privacy that have constitutional protection.
Let me ask you about your dissent in Casey. You reasoned that most women seeking abortions are either unmarried or would tell their husbands, and therefore few would be harmed if spousal notification was required. Justice O'Connor, on the other hand, ruled, and I quote, "The proper focus of constitutional inquiry is the group for whom the law is a restriction, not the group for whom the law is irrelevant," end quote. Why did you propose a different approach than Justice O'Connor?
Well, I mentioned the fact, in my opinion, that this provision applied only to married women, but I don't think that was really the focus of what I was getting at. I think I agree with her that you look at the group that's affected, not the group that's unaffected, and the standard that she had, so that would be women who fell within this provision of the Pennsylvania law, and the standard that she had articulated in the earlier cases was, as I described it a couple of minutes ago, that an undue burden, in her view, had to be an absolute obstacle or an extreme obstacle, and it could not be simply something that inhibited some women. The "some women" phrase was her phrase, not my phrase.
Now, I'm going to ask you one other quote that some of my colleagues may disagree with what she said, but she said it, and that is, "A state may not give to a man the kind of dominion and control over his wife that parents exercise over their children." Do you agree with that?
I never equated the situation of an adult woman who fell within the notification provision of the Pennsylvania statute with the situation of a minor who was required to provide notice. There's an analogy, and the earlier case that Justice O'Connor had decided, the Hodgson case, was a minor notification statute. But I think I made it quite clear, in my opinion, that this was nothing more than an analogy, and that there was no close, these situations were very distinct, and I was aware of that, and I think I pointed that out.
Let me move on, if I might. One of the core principles of Roe is that a woman's health must be protected. In Casey, O'Connor specifically wrote that after viability, the state, quote, "may, if it chooses, regulate and even proscribe abortion, except where it is necessary in appropriate medical judgment for the preservation of the life of the mother." This requirement to protect a woman's health was always also reaffirmed in Stenberg v. Carhart. where it was said the court rejects Nebraska's contention that there is no need for a health exception. Do you agree, if a statute that restricts access to abortion, that it must protect the health of the mother in order for it to be constitutional?
Well, I think that the case law is very clear that protecting the life and the health of a mother is a compelling interest throughout pregnancy. I think that's very clear in the case law.
Thank you. I appreciate that. In 1985, at the time you wrote the strategy memo on Thornburg, the court had already held that Roe, Akron, and eventually 30 other cases that a woman had a constitutional right to choose whether to continue a pregnancy. In addition, in your memo, you specifically wrote that in the Akron case, the Supreme Court reaffirmed Roe. However, despite this, your memo outlined a strategy to eventually overturn Roe. My question is a little different from what you discussed somewhat yesterday. What was your view of precedent at the time you wrote that memo?
Well, I think there are two things that I should say in response to that. The first is that I did not advocate in the memo that an argument be made that Roe be overruled, and therefore the whole issue, had the government proceeded with the argument that I recommended, the issue of stare decisis wouldn't have been presented. And so there wasn't any occasion for me to talk about stare decisis in the memo, and I did not talk about it. I think there's a mention of it in a footnote. So I didn't address it, and there wasn't an occasion to address it. The second thing I would say is that stare decisis is a concern for the judiciary much more than it is for an advocate. An advocate is trying to achieve a result. And so an advocate is, for an advocate, stare decisis can be either a great benefit if it is in your favor or an obstacle to get over. But it isn't the kind of issue that needs to be grappled with the way in which a court has to grapple with stare decisis.
Okay. In Casey, you wrote about the harms caused by spousal notification. You said the practical effect of a law will not amount to an undue burden unless the effect is greater than the burden imposed on minors. Just to go back to that, is this what you meant?
Well, Senator, I did not equate the situation of a married woman with the situation of a minor.
I know you keep saying that, but I keep going back to the words, and it seems they seem to say that.
Well, I think if you look at the words, I actually said that I don't equate these two situations. I was mindful of the fact that they are very different situations. But often the law proceeds on the basis, legal reasoning is based on analogy. And so if you take a situation that's quite different and yet has some relationship to a situation that comes up later, you can draw some analogies while still recognizing that the two situations are very different. If you're talking about the potential for abuse, that certainly is something that can come up in either of these two contexts. And it's a tragedy in either context. If a single minor is abused as a result of notification, that's a tragedy. If a single adult woman is abused as a result of notification, it's a tragedy. But what I think I'm getting at there is that this was what we had. This is what I had. This was the information that I had to work with to try to understand what this provision meant. And so you work with what you've got, and that's what I had, and I was trying to see to what degree the prior situation was relevant and to what degree it wasn't relevant to the issue that was before me.
I'd like to quickly just switch subjects for a moment, just to clarify something you said this morning. And this has to do with electronic surveillance of Americans. As you know, in 1978, the Congress, after a lot of introspection, passed a bill called the Foreign Intelligence Surveillance Act, which we call FISA, which essentially set up the parameters for all electronic surveillance within the United States. And it's very specific if you read it. there is a great concern right now because of what's been happening with respect to electronic surveillance, quite possibly involving Americans as well as foreigners. You said something interesting this morning. You said generally there has to be a warrant issued by a neutral and detached magistrate before a search can be carried out. Now, with respect to the FISA law, the committee report, Birch Bayh was the chairman of Intelligence Committee at the time. He spells out this covers all surveillance in the United States. And then President Carter, when he signed the law, said this covers all surveillance within the United States. So there is a burgeoning question as to whether the president now has the authority to wiretap Americans without going to the FISA court. When you said generally there has to be a warrant, what that said to me is you were providing for an exception. Is that correct? Are you providing for an exception?
I think that what I was addressing when I said that was what the Fourth Amendment means, the general principle that is set out in the Fourth Amendment. And the case law under the Fourth Amendment says that a warrant is generally required, but there are well-recognized situations in which a search can be carried out without a warrant. Exigent circumstances is a situation that comes immediately to mind if...
Well, let me stop you here. Do you recognize Justice Jackson's comment in the 1952 Steele case where he set up that tripartite framework for presidential authority? And when it is at its weakest is when Congress has legislated. And in 1978, Congress did legislate and covered the horizon, so to speak.
Yes, Senator, I recognize that, and I think that's a very useful framework for addressing issues of executive power. Now, there's a question about what the meaning of what Congress did, and that would be a statutory question. What is the meaning of the provision of FISA in question? And maybe there's no substantial argument about what was meant there, but maybe there would be an issue about what was meant there, and certainly there could be an issue about the meaning of the authorization of the use of military force. How far was that intended to go? And so the statutory question, I think, would certainly would be an issue that could come up in this situation, and probably you would need to, I think you would have to resolve the statutory question before you could figure out which of the three categories that Justice Jackson set out the case fell into.
Thank you. I've run out of time. I'll continue this next session. Thank you.
Senator.
Thank you, Senator Feinstein. Senator Sessions.
Thank you, Mr. Chairman. We've had a good hearing, I believe. A lot of exchanges have occurred. I will agree with Senator Biden. I can't remember a nominee being this forthcoming. You've gone into more detail and talked closer to questions that may come up before you without going too far, in my opinion, than we've seen before. You've been very open, and I've been very impressed with your analytical spirit and your ability to handle these cases. We need an aggressive hearing. I agree with those who say that questions need to be propounded to the nominee because this is the only chance that politically that we will have, that you will ultimately be on the bench for life, unaccountable to the political process. So it's good to ask questions. My concern is similar to that of Senator DeWine's, that many of the accusations and allegations are unfounded or distortions are really not fair. And some of the things that have been said about you are not correct. If they were correct, you would not receive the overwhelming support of your colleagues and have that admiration so totally as you do. Judge Alito, we talk about the role of a judge and how you handle cases that come before you. You were asked, what's your opinion on Lopez? And you said, well, I haven't studied that case. precisely, or at least the background of it. I didn't sit on it. Would you explain to us, as an appellate judge, as you do today, but also even more so as a Supreme Court justice, how cases come to you and what you should do before you make a decision or express an opinion on the ultimate outcome of a case? Why you should be careful, and what this great legal system that we have arranges for before a judge makes that final decision?
Well, certainly, Senator. We have an adversary system, and that means that both sides get the opportunity to present their arguments. And we have established judicial procedures, and they are time-consuming and they are burdensome, and maybe some people would say that some of them are old-fashioned, but I think they work well, and they are designed to make sure that there's a vigorous presentation of both sides of the issue that is presented in the case at hand, not some abstract issue that might be addressed in a law review article or a broad issue that might be addressed in a piece of legislation, but an actual concrete case, a dispute between real parties that comes before the court. Both sides have the opportunity to present the arguments that they think have a bearing on that case. The judges get the opportunity to read the briefs, and then in the Supreme...
Can I interrupt you there? And you're talking about the appellate court.
That's correct.
There has been a trial with jurors and witnesses and trial judges and those kind of things that's already occurred. It's now on appeal. No witnesses are being called, but the transcript is available, and one side or the other is alleging that they weren't treated fairly. Is
Yes,
that correct?
That's correct.
So you decide whether or not a fair trial occurred, and how do you continue now with the process and how you ultimately come to make a decision?
Well, we receive briefs, and the briefs are well thought out by the attorneys, and it provides, if the case is well briefed, a strong presentation of the positions on both sides of the question. And if it's an issue of great public importance, there may be other people who file briefs, so-called friends of the court. And on the Supreme Court now these days, they get a lot of those on both sides of many of the big issues that come before them. So that ensures that they have a strong presentation of all the arguments that can be made on both sides of the issue, both sides of the case. And the first step in the process would be to read all of those, and then there would be an oral argument. And then at that point, the justices of the Supreme Court or the judges of my court.
Now, oral argument means the lawyers for each party come and orally argue the case before the court. Is that correct?
That's right. And
now, you should not have made up your mind even at that point, should you?
You shouldn't. I think very often I come into an oral argument with a tentative idea about how the case should be decided. I've thought through the issue as much as I can, but my mind is open to the possibility that something will happen during the oral argument or later in my discussion with the other judges that might change my mind. So we have the oral argument, and the lawyers will make their presentation, and in that situation, I have the opportunity to ask questions, unlike today, and that's a better situation to be in, but it gives me a chance to explore the issues in the case that are troubling to me, and I can pose hypotheticals to the lawyers and try to explore how far their arguments go. And after we have the argument, the judges get together in what's known as the conference. That's a private meeting when just the judges are present, and we each discuss the case. And very often, one of my colleagues will say something that makes me think about the case differently than I did going into the conference. But at the end of the conference, if we've all voted, then we exchange our views and we come to a conclusion about how the case should be decided. And it's only at the end of that process that we actually have a vote on the decision. And then somebody is given the job of writing an opinion. And sometimes things even change during the opinion writing process. There have been numerous cases in which I've had the opinion and I've been given the job of writing an opinion to affirm, and in the process of, or to reverse, and in the process of writing the opinion, I see that the position that I had previously was wrong. I changed my mind. And then I will write to the other members of the panel, and I will say, I've thought this through, and this is what I've discovered, and now I think we should do the opposite of what we agreed, and sometimes they'll agree with me and sometimes they won't. So it's a long process, and it's only at the end of that whole process that I think a judge is in a position, when the opinion is actually going to be issued, the judge is in the position to say, now I've done everything I can with this, and this is how I analyze the issue.
And you said in your opening statement that one of the habits of minds that a good judge should develop is the habit of delaying reaching conclusions until everything has been considered. And I suppose that's why you would be somewhat reluctant to express an opinion on Lopez or Bush versus Gore or some of these other great decisions, because you would know before you rendered such an important decision in a case like that, that you've given it the most thorough analysis and you've heard from all the briefs and considered all the arguments of the parties involved. Is that correct?
That's an important part of the legal process. If anybody has sat on a jury, they've probably been instructed by the judge not to reach any conclusions about the case until they've heard all the evidence, not to reach premature conclusions, and the judges have the same obligation. And now, it doesn't mean you don't think about things. You do think about them, but you don't reach your final conclusion until you've gone through this entire process.
Well, you said earlier that no person in this country, no matter how high or powerful, is above the law, and no person is beneath the law. Can you assure us that you have the courage and the determination to rule according to your best and highest judgment of the value of the case, regardless of whether or not it's the person who appointed you or the Congress who confirmed you or any other political pressures that may fall upon you?
I can, Senator. I would do that to the best of my ability. That's what I've tried to do on the Court of Appeals, and if I'm confirmed, that's what I would do on the Supreme Court.
Well, I believe you will. That's your reputation. That's what other lawyers say about you. That's what professionals who know you conclude. And I think it's an important commitment that you've made to us. You know, we have arguments about a number of cases, and the Rybar case has come up a good bit. It involved the machine gun. I was a United States attorney, as you were, and we prosecuted machine gun cases for years. The Supreme Court has, in the 922, under Section 922, there's no jurisdictional element. Now, historically, criminal statutes of federal law have jurisdictional elements. The most common statutes historically that were prosecuted were interstate transportation of stolen motor vehicle. It's not a stolen motor vehicle, it's the interstate transportation that makes it a federal crime. Or the interstate transportation of a stolen property. Or kidnapping. Kidnapping within a state is not a federal crime. It's only kidnapping that goes interstate. So I guess I would ask you to explain for those who may be listening today what this historical procedure is that requires a jurisdictional element of an interstate nexus for the federal government to be able to prosecute a crime in some state or county in America.
Yes, Senator, certainly. Well, let me start with the Constitution. The Constitution gives the legislative branch certain powers, and they're enumerated in the Constitution. One of those powers is the power to regulate interstate and foreign commerce, and a great deal of legislation that Congress passed during the 20th century was regulation that was based on its power to regulate interstate and foreign commerce. And many of the criminal statutes that Congress has passed, the federal criminal statutes, are based on Congress's power to regulate interstate and foreign commerce. So it's necessary for each of these statutes to fall within this power to regulate interstate and foreign commerce. And one of the ways of ensuring that each exercise of this power falls within Congress's authority under the Commerce Clause is to require that the jurisdictional element be proven in the case. And in the case of firearms, as I mentioned earlier, the Supreme Court has said it's enough to show that the firearm at some point in its history traveled in interstate and foreign commerce. And my experience as a U.S. attorney and before that as an assistant U.S. attorney was that this is not a difficult burden for prosecutors to meet. I can't recall a case during the time when I was U.S. attorney where anybody expressed the slightest problem with satisfying this. So this is a very simple way of satisfying the interstate commerce element in the case of firearms offenses.
I couldn't agree more, and that's what all the traditional firearm laws call for. And that's how we proved every case that I prosecuted. You'd put somebody on, I proved it once because it said made in Italy on the gun. But you proved that the gun had been transported in interstate commerce, and that's an element that gives the federal jurisdiction. And as I understand your opinion, you said if the Congress had simply put that in the statute as an element of the offense, then it would have met constitutional muster. So I guess I'd say to my colleagues on the other side and others, maybe we ought to check this law out and let's get up a piece of legislation that puts in the jurisdictional element, like all the other historic criminal offenses have, and we get this thing done instead of fussing about it. I feel strongly about that, and but when you don't make it a jurisdictional element, then it's not a matter of proof. Is that not right, Judge Alito? And therefore, the defendant is not having all the elements of the case proven to a reasonable, beyond a reasonable doubt to the jury that hears the case. That's why it's important.
That's correct.
We talked about a lot of these cases that I would just generally like to express my disagreement with those who criticize the Garrett case. Did involve the University of Alabama, and I believe that the Attorney General of Alabama was correct to assert that the plaintiff could sue, could get back wages, could get their job back, but under the sovereign immunity doctrine that protects states from lawsuits, that under the way that statute was passed, they could not get money damages against the state of Alabama. I think that was a core issue in it. I also would like to join with Senator DeWine in his very cogent analysis of precedent and super precedent. I think that was insightful for us, and would like to be on record as joining with that. Judge Alito, back 20 years ago, you wrote a memorandum to Solicitor General Charles Freed, who was a law professor, I guess, before he became Solicitor General and went back to Harvard and is there now, a brilliant legal mind. He was the Solicitor General. You worked for him. You submitted a memorandum on a Pennsylvania case that came out of Pennsylvania, and it was seemed to me to be a preliminary analysis of that issue and the question of whether or not that case should be, whether the Department of Justice should intervene in that case and file a friend of the court brief. Was it a preliminary overview of the issue and not the final brief or final summary of argument for the appeal?
And that's the Thornburg case that you're referring to, Senator. Yes, it wasn't the brief. It was a memorandum about whether the government should file a brief as a friend of the court.
And you pointed out a number of points in that decision that was being questioned that I thought were the court had overreached and gone too far. A number of them are quite erroneous, it appeared to me, and you analyzed that very carefully. But before you concluded your argument, you suggested, and not suggested, you stated that you did not think a frontal assault on Roe versus Wade would be appropriate. Is that correct?
Yes, that's correct.
And was it not the position of President Reagan and the Attorney General of the United States at that time that Roe versus Wade was wrongfully decided, and they would seek the opportunity at some point to seek the overruling of it?
That was the express position of President Reagan himself. He had spoken on the issue, and he had written on the issue.
So your opinion to the Solicitor General as a young staff attorney in the Solicitor General's office was it in some ways contrary to that of the President of the United States?
Well, I was doing what I thought my job was as an advocate, which was to outline the litigation strategy that would be in the best interests of my client, given what my client was interested in, and it seemed to me that the strategy that I recommended was the best strategy to be followed.
And did they follow your suggestion?
No, they did not. They argued that Roe versus Wade should be overruled, and the Supreme Court rejected that. They,
argument. In fact, carried out a frontal assault, and it was not approved by the court. So I think that, to me, plus your other decision in which you ruled that Health and Human Services funds could be utilized to fund an abortion for those who qualified, was a close question. That case was, I thought. There was a dissent in it, but you ruled in favor of the pro-choice, the pro-abortion side of that case, even though a dissent argued that it was in error. Is that correct?
That is correct. That's what I thought the law required. I thought we were required to defer to the Department of Health and Human Services interpretation of the statute, and so that's how I voted. And if I had been out to implement some sort of agenda to strike down, to uphold any abortion regulation that came along, then I would not have voted the way I did in that Elizabeth Blackwell case.
Back in your memorandum about in 1985 on the question of abortion, one of the provisions of the Pennsylvania law that was struck down by the Court of Appeals simply said that there must be a humane and sanitary disposal of aborted fetuses. And you thought that was unwise, and you pointed out that there's a federal statute already on the books that mandates the humane disposal of excess wild, free-roaming horses and burros. Did you not?
Yes, that's correct. That was the statute.
So this idea that every time a court rules on a pro-abortion opinion, that they're always correct, I think is not true. I think the court has been awfully arrogant and dismissive of the state's rights and legitimate concerns in some of these questions that we're dealing with. Judge Alito, you know the salary that a federal judge makes, is that right?
I do, all too well.
You know what it would be on the Supreme Court?
I actually don't know exactly, no.
A little more, I think. Not much. You think you can live on that?
I can. I've lived on a federal judge's salary up to this point.
You've been accused of favoring an all-powerful executive a couple of times in this committee. Can the president cut your pay?
No, he can't do that. That's in the Constitution says that, fortunately. Well, nobody can. The president certainly can't, and Congress can't either.
Have a sigh of relief there. They can increase it, though, right?
They can, yes.
Well, we have a tight budget. Senators and congressmen feel sometimes privately they'll tell you they think they need to be paid more, but we're paid pretty generously in my view, and maybe we need to set some examples about financial management, and maybe we'd like to do more, but it's difficult. But I raise that point because a Supreme Court can declare null and void a legislative enactment by the Congress, can it not, if it violates the Constitution?
Yes, it can.
In their opinion?
Yes.
Does anybody review the Supreme Court's review?
No.
And Congress can cut off money for any program they want to. In fact, there's the Anti-Deficiency Act says it's a crime for any agency of government to spend money that has not been appropriated by Congress. Is that a reviewable act by anyone for Congress not to fund a program or agency of the United States government?
No, I don't think that's reviewable.
And aren't there things that the executive branch can do that are not reviewable?
There are certainly some things that are not reviewable. Vetoes are not reviewable. Pardons are not reviewable.
So the mere allegation that an act of the president is unreviewable does not may not be as disastrous as it sounds, or as bad as it sounds, because certain branches are given given certain powers.
That's correct.
I'd like to talk a little bit about this question of activism, and I want to be frank about it. Some of our liberal colleagues have correctly made the point that conservatives can be activists too. Would you, and if you take the definition of activism as an action by a judge who allows their personal, political, or social, or moral values to override their commitment to the law, do you believe that a judge who's conservative can be an activist just as easily as one who's liberal?
Yes, I do. I don't think that activism has anything to do with being a liberal or being a conservative. It has to do with not following the proper judicial role. It has to do with a judge's substituting his or her own views for what the Constitution means and for what the laws mean.
Now, if a statute passed by Congress plainly violates the Constitution, is it an activist decision if the court strikes it down, in your opinion?
No, I think that's been settled since Marbury versus Madison back at the beginning of the 19th century, that when a case is presented to the Supreme Court and there's a question raised about the constitutionality of a statute and the court concludes that the statute is unconstitutional, it's the obligation of the court to follow the Constitution and not the statute.
Well, if you take the definition of activism, I think that Senator Hatch and others have used that indicates, as we just discussed, that it's departing from the faithful application of the law. I think you can have liberal and conservative activists. But I would just say to you, the mere striking down of a statute that's unconstitutional is not activism, not if you're faithful to the Constitution and to the laws of the land. And I would say this, I believe on our side of the aisle, the deep concern we have about judicial activism is a legitimate one. We believe that there has been a liberal social agenda being promoted too often by the courts that's foreign to our history and contrary to the wishes of the American people. I believe your philosophy is not one to enforce a conservative activism. I believe your philosophy is simply to follow the law and let the political branches debate these issues and decide them through the popular political process. Is that fair to say?
That's exactly correct. The judiciary should do what it is supposed to do, but it has to have respect for the political process. And our constitutional system sets up a government under which most of the decisions, the policy decisions, the things that affect people in their daily lives, the spending of money, taxing, decisions about foreign policy, and many other areas are to be made by the political branches of the government, and the judiciary's role is confined to enforcing the Constitution and enforcing the laws and not going beyond that.
As you analyze how to interpret the Constitution of the United States or a statute passed by the United States Congress, do you believe that authoritative insight can be obtained by reading the opinions of the European Union?
I don't. I don't think that it's very helpful. In fact, I don't think it is helpful to look at the decisions of foreign courts for the interpretation of our Constitution. I think we can do very well with our own Constitution and our own judicial precedents and our own traditions. And I don't say that with disrespect to the other countries, but I don't think that there are insights to be provided on issues of American constitutional law by examining the decisions of foreign courts. I think that it's very interesting from a political science perspective to see what they've done, and I've personally been interested in this over the years, and I think it's flattering to us that so many other countries have followed our judicial traditions. But on issues of interpretation of our Constitution, I don't think that that's useful.
Judge Alito, this is a big deal in our country today. Millions of Americans believe that the court is losing discipline, that it's not remaining faithful to the Constitution. And in fact, I share many of those views. A lot of people do. And do you think that if a court, in fact, is not faithful to the law, but allows personal or political or social views to influence their decisions, that this could, in the long run, endanger public respect for law and even undermine the great heritage of the rule of law that we have in this country?
I think that everybody who holds a public office under the Constitution has a solemn responsibility to follow the Constitution and the laws that define the role that that officer is supposed to play. And I think that the continued success of our constitutional system and public respect for the constitutional system are dependent on people who have the public trust doing that, making a strong effort to follow the provisions of the Constitution and other laws that define the role that they are supposed to play.
I'd like to just once more touch on this Grudy case in which there was a search of a young girl. A warrant was issued, was it not, by a federal magistrate? Was it a federal magistrate?
It was a state magistrate.
State magistrate. And the police officers go to the state magistrate and they get a warrant, and the magistrate says that the affidavit is made a part of the search warrant, and the officers take it, and in their search warrant they made affidavit that the individuals in this house known for distributing drugs often had drugs on their persons, and they then went and executed the warrant after going to the court and getting approval, and they find people on the premises, and there were two females, and a female officer took the two females into a bathroom and did a quick search by asking them to pull down their outer garments, not all their garments, pull up their blouse, and determined they had no contraband or weapons on them. And that was that. And the case came before you years later, I suppose, on a lawsuit against the police officers. And that's what you were ruling on, were you not?
That's right, whether they were liable for money damages. And under the law, if they had a reasonable belief that they were authorized by the warrant to search people who were found on the premises, then they should not be liable for civil damages. The warrant had incorporated the affidavit for purposes of establishing probable cause, and the officers had said in the affidavit that there is probable cause to believe that people on the premises may have drugs on their possession, and the magistrate judge had accepted that by incorporating the affidavit for purposes of probable cause. And under those circumstances, I thought that at a minimum it was reasonable for the officers to believe that the judicial officer, the magistrate, had said that they were to do exactly what they did.
I agree. Thank you, Mr. Chairman.
Thank you, Senator Sessions. Thank you, Judge Alito. At this point, we'll take a break until 5 minutes to 5.
See you.
Phone call text. Well,
Looking good.
you can get them on 5 if you talk down there like a direct phone.